Everything that is explained in this video is summarized from the CoinMarketCap news update on XRP, by the way. Take a look at this. XRP, Ripple, and the UCC agreement set course for transparent XRP lawsuit progress. In the ongoing legal dispute between Ripple Labs Inc. and the United States Securities and Exchange Commission (USC) over the status of XRP, both parties have recently presented a joint sealing request to the United States District Court for the Southern District of New York. This motion is intended to seal some information about the cryptocurrency, timeline of events in the legal struggle between Ripple and the SEC, an organized approach to handle sealing and redaction concerns for prospective remedies. Related briefings is outlined in this proposal. This method demonstrates the commitment of both parties to transparency while still acknowledging the necessity for secrecy in specific situations. An important new development in the ongoing legal dispute is the establishment of a planned timeline for the court proceedings between Ripple Labs Inc. and the United States Securities and Exchange Commission by outlining a specific timetable for the submission and public release of court papers. This timeline highlights the significance of transparency while simultaneously acknowledging the requirement to safeguard sensitive material through the use of redaction. A comprehensive summary of the legal timeline involving Ripple and the Securities and Exchange Commission (SEC) is planning to submit its opening remedies related brief under seal beginning on March 22, 2024. A review phase will be conducted to identify any sensitive content that should be redacted before the document being made available to the general public. This initial step will set the stage for the review period. It exhibits a proactive approach to protecting personal data while simultaneously establishing the framework for eventual litigation. For Ripple and the Securities and Exchange Commission, the 25th of March 2024 is a major milestone since it signals the beginning of collaborative efforts to reach an agreement on redactions to the SEC's opening brief and its accompanying materials to ensure that the public has the greatest possible access to information that is relevant to the case. The goal is to reduce the number of redactions as much as feasible. This endeavor, which is being undertaken in collaboration, highlights a dedication to transparency and constructive engagement between the parties concerned. After that, on March 26, 2024, it is anticipated that the Securities and Exchange Commission will submit a public version of its opening brief that has been redacted. This version will only include the redactions that have been agreed upon by both parties. The implementation of this step contributes to increased openness by guaranteeing that vital information is available to the general public while simultaneously protecting sensitive data in the appropriate manner. The anticipated filing of Ripple's opposition brief and supporting documentation is scheduled to take place on April 22, 2024, according to the progression of the proceedings. Any confidential information that may be contained within these files will be subject to redaction, even though they will be filed in a public repository. Because of the complex nature of the legal proceedings, this strategy strikes a difficult balance between being transparent and maintaining secrecy. Following this, the 23rd and 24th of 2024 is scheduled to mark the beginning of conversations and filings regarding redactions that are particular to Ripple's opposition brief and the materials that support it. The purpose of these discussions is to address any issues that may still exist regarding the safeguarding of sensitive information, thereby further refining the transparency measures that have been established throughout the process. The Securities and Exchange Commission, the MES, will file its reply brief under seal on May 6, 2024, which will mark the culmination of the scheduled submissions. Subsequent conversations and filings will center on the creation and dissemination of public versions of the SEC's reply brief that have been redacted. This will ensure that the public is kept informed while still protecting sensitive material. At long last, beginning on May 13 and continuing through May 20, 2024, the attention will be directed toward the filing of omnibus letter motions to seal materials related to the remedies-related briefing. This will be followed by letter briefs that are opposed to motions to seal papers, which will generate a dialogue about the necessity and extent of sealing specific documents and information. Within the context of the XRP legal struggle, transparency, and confidentiality, by utilizing this structured time frame, the parties have demonstrated their dedication to maintaining transparency throughout the entirety of the legal procedures about XRP. The objective of the joint sealing proposal is to strike a compromise between the public's right to information and the preservation of sensitive economic and legal data. This will be accomplished by providing explicit standards for sealing and concealing information. One of the most significant aspects of the case is brought to light by Bill Morgan, a sharp observer from the XRP community. A protection order has been placed on the disclosure of Ripple's post-complaint contracts with institutions, which means that information is only accessible to the SEC. This is even though the SEC has filed a motion to seek the disclosure of these contracts. Ripple is likely to seek redaction and sealing of commercially sensitive material in the SEC's brief and reply brief, according to Morgan, who points out the possibility of this happening. As the case regarding XRP moves forward, the joint sealing request and planned timeframe provide a foundation for transparent judicial procedures while still fulfilling the requirement for confidentiality. Even though the parties are making an effort to be transparent, the existence of protection orders highlights the fact that certain material that is involved in the case is extremely sensitive. During this time when stakeholders are eagerly awaiting additional developments, adhering to a methodology that is both transparent and structured ensures that critical information is available while still protecting confidential data. The United States District Court for the Southern District of New York has received a joint sealing proposal from Ripple Labs Inc. and the United States Securities and Exchange Commission in the case involving XRP. The proposal was presented by the parties. This proposal, which is intended to govern sealing issues for the upcoming briefing related to remedies, provides an opportunity for both parties to demonstrate their commitment to transparency while simultaneously acknowledging the importance of maintaining confidentiality for certain sensitive information. A plan for the submission and public release of court papers is outlined in the joint letter that was sent to the Honorable Annalisa Torres on March 19, 2024. The letter also emphasizes the importance of taking a methodical approach to sealing and redacting document information. With the following statement, the parties make their intentions clear. The proposal will ensure prompt public access to the parties' briefs about which any proposed redactions are anticipated to be minimal, which is consistent with that strong presumption of public access. The timeline of Ripple's detailed remedies about the SEC 22nd of March 2024. All of the supporting declarations and exhibits, as well as the opening remedies related brief, are going to be filed under seal by the Securities and Exchange Commission issue. Before the documents are made available to the public, this preliminary phase allows the parties to examine them and determine whether or not they contain any sensitive material that requires read. And it is quite likely that the SEC brief and reply brief would contain a significant amount of information that is commercially sensitive and will be subject to encryption. The information that has been provided is not intended to be trading advice for any investments that are made based on the information that is provided on this page. Before making any decisions about investments, we strongly advise conducting independent research and consulting with a knowledgeable professional.